before we jump into the panel, we're going to have a keynote speech by the Honorable Bertha Josephson, and it's my great pleasure to introduce Judge Josephson to you. She has a very interesting background. She has been a lawyer, I just calculated, approximately 40 years. She spent 5 years working within the National Institute of Corrections, doing investigations and working on prisoner rights issues. She then spent several years as an assistant district attorney, where she was the head of the Civil Rights Division. She also worked as a U.S. Assistant Attorney General. In 1992, she was elevated to the District Court of Massachusetts, and in 1994, she became a Superior Court judge in Massachusetts. I think any of us that have appeared before Judge Josephson would say she has a sharp mind, a sharp wit, and she is also, as a trial attorney, the best thing you can ever say about a judge is they let you try your case. And that's what Bertha Josephson does. She knows the evidence. She doesn't get in your way. She lets you try your case. Doesn't let you go off the rails, but will keep you straight and narrow. So without further ado, I introduce the Honorable Bertha Josephson.
I want to thank all of you for being here, particularly on this rainy day. I saw you all snaking your way here, and you had to walk some distance, didn't you, to get here? What I wanted to tell you was that as a kid growing up in the 60s, there were two things that I knew verbatim from watching way too much television, and I'm sure if you woke me or many of my fellows from a sound sleep, we could have recited these two things to you verbatim without hesitation. The first was from a commercial, and please join in at any point that this sounds familiar, and that was that Crest could be an effective decay-preventing dentifrice that could be of significant value when applied to a conscientiously applied program of oral hygiene and regular professional care. So it's in there somewhere. The things you're watching now, they are in there somewhere. And 40 years hence, you will be also probably trying to wipe them out. Thank you. The other thing that I could tell you without hesitation was that if arrested, I had the right to remain silent. Anything I said could and would be used against me in a court of law. I had the right to an attorney, and if I couldn't afford one, one would be appointed to represent me. As an elementary school kid, neither one proved very useful in my life. But the second one proved to be an important part of my professional life as an adult. So that's what we're here to talk about today. And where did that important incantation known as the Miranda warning come from? And how did it come to be? Well, as you probably know, in 1966, the case of Miranda versus Arizona was a case in which the Supreme Court took an unlikely case that made its way to the Supreme Court to articulate an important interpretation of constitutional rights that previously had been left in a state somewhat of confusion. The Supreme Court sought to clarify the application not just of the Fifth Amendment right to remain silent, but it also took to clarify the application of the Sixth Amendment right to counsel that had been the subject of two earlier landmark decisions. You may have heard of them. Gideon versus Wainwright, which extended the right to be represented by an attorney to those who could not afford to hire their own. And then the 1964 Escobedo versus Illinois, in which the Supreme Court held that a person being held in custody and questioned must be allowed to consult with an attorney. Escobedo actually resulted in not the model of clarity for the state courts, and so it was being applied in different ways in different state courts. So 2 years later, in Miranda, then Chief Justice Earl Warren found the opportunity that he was seeking for his court to clarify and expand these rulings and to clearly delineate the responsibility of law enforcement to ensure that individuals in custody were fully aware of their right to an attorney under the Sixth Amendment and their right to remain silent. In other words, to be free from being compelled to give evidence against themselves under the Fifth Amendment, and also that those rights be waived voluntarily before being interrogated. Now, the notion that the Fifth Amendment required any statement obtained during a police interrogation in which the person being interrogated was in custody, that be voluntary, was not a new concept. It had been articulated as early as 1897 in Bram versus the United States, which required that any confession offered in court must be freely and voluntarily given. What Miranda did was to bring that requirement of voluntariness into clearer and sharper relief by specifically requiring police or law enforcement officials to explicitly advise a defendant of the Fifth and Sixth Amendment rights and then obtain a voluntary waiver before any custodial statement could be used against that person. So the language that we're so familiar with and that I think you have on your little cards is taken directly from the Supreme Court decision that became known as Miranda. And actually, Miranda later on became a verb. If you talk to police officers, they will say that they Mirandized a defendant. It turned out to be not a bad name for a case that was going to be cited so frequently. So these things don't exist in a vacuum. It's oftentimes, as we listen to somebody like me talking about the finer points, perhaps, of Fifth Amendment application and Sixth Amendment, and we call it Miranda. Well, but what really happened? Who are these people? It really gives it form if we think for a moment and have the opportunity to learn who Ernesto Miranda was and how did his case ever get to the highest court in our country. Well, on March 13th of 1963, Ernesto Miranda was a 23-year-old with a ninth grade education and a tragically deprived and neglected childhood. He was arrested by the Phoenix Police Department, and based on circumstantial evidence that linked him to the kidnapping and rape of an 18-year-old developmentally delayed woman 10 days before, the police sought him out. After 2 hours of what everybody agreed was non-threatening interrogation by the police officers, Mr. Miranda signed a confession to the rape charge on forms that included a typed statement that said, "I do hereby swear that I make this statement voluntarily and of my own free will with no threats, coercion, or promises of immunity, with full knowledge of my legal rights, understanding any statement I may make may be used against me." So that's what Mr. Miranda, with his ninth grade education, signed. He was not told of his right to counsel. Before he was presented with the form on which he was asked to write out the confession that he had already given orally anyway, he was not advised that he had a right to remain silent, nor was he informed that his statements would be used against him. At trial, when the prosecutors offered Mr. Miranda's written confession as evidence, his court-appointed lawyer objected to that confession, saying it was not truly voluntary and it should be excluded. The objection was overruled, and based on that confession and other evidence, Mr. Miranda was convicted of rape and kidnapping, and he was sentenced to serve a whopping 20 to 30 years in state prison. His attorney filed his appeal with the Arizona State Supreme Court, and that court affirmed the trial court's decision, and it relied heavily in making that decision on the fact that Mr. Miranda did not specifically request an attorney. Now, interestingly, the right to counsel proved important in his case, also factually, as he was represented, as I mentioned, by a court-appointed attorney. That attorney's name was Alvin Moore. And Mr. Moore, Attorney Moore, was paid a grand total of $200 for all of his representation of Mr. Miranda. Mr. Moore was 72 years old at the time that he was involved in Mr. Miranda's case, and Mr. Moore even remarked to the jury during the trial that he didn't like these kinds of cases, but even people accused of awful things deserve representation. That's the kind of statement that I think a judge ought to step in and say, "What are you doing?" I don't like my client's case, but nonetheless, that was not actually a shocking statement at the time. But it also, to me, emphasizes the commitment of attorneys like Mr. Moore and all of the attorneys who we are fortunate to have practicing in the Commonwealth and elsewhere, the commitment of attorneys to represent clients zealously, regardless of their personal opinions, and the professional standard that attorneys take to ensure that at least some of the cases that they take on are cases that they take on for free, or pro bono, as it's called. So it's interesting that it was this 72-year-old court-appointed attorney paid $200 who brought a case that became the most cited case in American jurisprudence to us. What ended up happening was, after they had exhausted their remedies, as we call them, or their appellate rights in state court, the case came to the attention of the ACLU. And through that, two very highly regarded attorneys from a prestigious Phoenix law firm were contacted to represent Mr. Miranda in his appeal. Oh, the American Civil Liberties Union. Thank you. A good clarification point. Thank you. So the American Civil Liberties Union was prominently, or not prominently, but was certainly involved in the movement of this case to John Flynn and John Frank, who were the two attorneys who represented Mr. Miranda, and submitted a petition on his behalf to the Supreme Court. So how, out of all of the petitions that are filed in a year, did Mr. Miranda's case end up being taken by the Supreme Court? Well, as I mentioned, in 1965, Chief Justice Earl Warren was actually looking for a case that would give his court the opportunity to clarify that Esposito right to counsel decision and to articulate a standard for voluntariness. So he had his law clerks go through petitions for appeal that had been submitted and identify those appeals that involved a right to counsel and mark on them Esposito. That is how Mr. Miranda's case, along actually with three other cases that were decided in the same time, were identified and accepted for review before the U.S. Supreme Court. Well, as you know, that case resulted in a decision issued on June 13th of 1966, written by Chief Justice Earl Warren, who, by the way, was a former prosecutor, and that decision was in favor of Mr. Miranda, and it ruled, interestingly, I think, because, as you'll recall, it was pretty much conceded that there was no heavy-handedness in the dealing with Mr. Miranda. However, the ruling stated that essentially due to the inherently coercive nature of any custodial interrogation by the police, no confession could henceforth be admissible under the Fifth Amendment self-incrimination clause and the Sixth Amendment right to an attorney unless a suspect had been made aware of his rights and he had then waived them. So the language, as I said, was taken exactly from that decision. Mr. Miranda's conviction was overturned, and that language became the words articulated in countless cases, both real and fictional ones that we've all seen on TV, and that are printed on cards that are carried by law enforcement throughout the country to this very day. And let me just say, in reflecting on the Miranda decision today, there are two things that come to mind about the political landscape that affects the judiciary. I just want to touch on them briefly. The first is the importance of an independent and strong judiciary. As you may suspect, the Miranda decision was a very unpopular one in its day. And in fact, Congress in 1968 passed a law that would have effectively overridden the decision. For various reasons, that law was never enforced, and so it was not challenged until the year 2000, when it was struck down by a Supreme Court decision with a 7-2 majority. And by that time, the Supreme Court found that the rights that were articulated in the Miranda decision were so accepted and so deeply ingrained in the American culture as to be unassailable. So here's the answer one has to wonder, but I think we know, the answer to the question of what would have happened if the Supreme Court, like many state courts from which cases like Miranda arise, what if the Supreme Court was populated by elected judges? Well, I think we know what would happen is fairly clear from what has happened in the state courts where judges are elected and when they've made unpopular decisions, such as when the California courts struck down the death penalty. Where judges were elected, they were voted out. Now, without an independent judiciary, and without ensuring that by removing the judiciary from the electoral and political process, cases like Miranda that apply constitutional principles that may not be in popular fashion at the time would not be possible, and no forward movement in social justice would be possible. And then the second aspect that I just want to touch on that we must wonder about when the Miranda case is considered in light of our current political climate is whether the decision could be made at all today, literally today. It was, after all, a narrow decision. It was 5 in favor and 4 opposed. If it were before the court at this very moment, it could not be decided because there is no 9th justice to break a 4-4 tie. The case would have stood on the state court's decision, and there would be no Miranda rights. So in conclusion, you might be wondering what happened to Mr. Miranda and his case after the decision. Well, the confession was excluded. He was retried, but without that confession. But he was convicted again. And he was convicted again largely because of the evidence that was given against him by his girlfriend, to whom he also confessed. He was sentenced, and he served 11 years in state prison. After his release, he made some money briefly by signing those what were then or became ubiquitous Miranda warning cards, so he would sign them and get some money for that. But 6 years later, he got into a bar dispute over a small amount of change that was left on the bar, and unfortunately, he was stabbed to death. The man accused of killing Ernesto Miranda was never convicted. He was taken into custody, but he refused to speak after being given the rights that bore the name of his victim. So he was released, he fled to Mexico, and Mr. Miranda's killer was never brought to justice. However, justice prevailed in that confessions that are given in custodial situations clearly now cannot be used unless the voluntariness has been established and the rights have been given. So I want to thank you very much for your kind attention during these remarks, and I'll look forward to us hearing more from you when we get to the discussion part.
Next on our program is very interesting discussion we hope to be having. We have three very experienced and very diverse panelists. The first is Officer Cody Gilbo at the end of the podium here. He is a proud graduate of GCC. He is also a graduate of the Police Academy in Massachusetts. He has been a police officer since 2010. He currently serves in the Greenfield Police Department, and he is what we call the downtown beat officer. He's on foot. I see him often. I wave at him. And he helps keep things in the downtown moving, people moving, and has his fingers on the pulse of what's going on. So he's an invaluable addition down there. Secondly, we have Caitlin Rock. Caitlin is an assistant district attorney. She is a proud graduate of Salvo Regina, where I wish to attend. Which I always look at her. I did not go. She did. She also is a graduate of Pace University. She has been an assistant district attorney in the Northwestern District Attorney's Office the entire time. Is that correct? Since 2004. And in 2006, she was assigned and asked to focus on juvenile justice issues. She is the primary prosecutor in the juvenile criminal session. And having worked with Caitlin numerous times, I would say that not only is she a great trial attorney, but she also takes a very holistic view of cases that come before her. She's interested in diversion. She's interested in figuring out why these juveniles are there, what's going on, and not just putting a Band-Aid or a punishment on a situation that probably needs therapy, diversions, other ideas. So she's been very active in all of those roles, and I applaud her for that. Next is Jennifer Cox, who I have the great pleasure of sharing a law office with. Jennifer is a graduate of St. Michael's University. I believe it's a university now. It's still a college in Vermont. She went to New England School of Law, where I had the pleasure of meeting her one fall morning in 1986. She has been in private practice since 1989. She's done everything from big firm litigation out in Detroit to small firm personal injury workers' compensation work. For at least the last 15 years, she's focused on serious felony cases, mainly in the superior courts. She is a very, very experienced and I think very well-respected trial attorney. And they will be speaking on a fictional scenario. This is the fictional scenario that the panelists will be dealing with. So here we go. Brandon Salinger was a 15-year-old high school sophomore and the regional championship of his wrestling group. He's only 15, but he is 6'2" and weighs 220 pounds. During several tournaments last year, he was often mistaken for the team's assistant coach because of his physical appearance and mature demeanor. Now, one day during his social studies class, Brandon, apparently skipping school, went to the mall, and he had in tow his 18-year-old sister, who parenthetically probably should have known better. They went shopping for a tie for homecoming, and she picked out this god-awful paisley tie she wanted him to wear. He didn't want to wear it, so she stuck it in his back pocket anyway. They then found nothing that they liked in the men's formal wear department, so they left the store and went back into the mall. Sam Sanchez was a security guard employed by mall service at this time. He was on duty that afternoon, and he saw Brandon walking around with the green tie and the price tag hanging out of his back pocket. Sam had been told by the department store manager, that there had been an increase in shoplifting due to homecoming season. So he became suspicious. Might have been the price tag. He approached Brandon and said, "You got a receipt for that tie?" When Brandon could not produce the receipt, the security guard escorted Brandon and his sister away from the public shopping forum and into the mall's security office. Anita Colton, who was a city police officer but worked part-time as a security guard at Mall Secure, she was there that day, and she was getting ready to end her part-time job and go to her full-time job at the police station. She had put on her police uniform, she had a badge, and she had a firearm. Security guard Sanchez, put Brandon in an empty office and took Katie into another room to question her. Now, the empty office where Brandon was had a window looking into the outer reception area to the security office suite, and Brandon could see people coming and going from the front door. Officer Colton entered the room where Brandon was seated and closed the door. She then asked him, "Do you have a driver's license? Let me see it." Brandon said, "I don't have a license. All I have is my school ID." He handed that over. School ID did not give his age or the year he was in school. Officer Colton responded by raising her eyebrows and asking him, "Can you tell me your exact date of birth?" Based on his stature and his mature appearance, Officer Colton suspected that Brandon was misrepresenting his age, which apparently was a common tactic used by shoplifters because they hoped to be sent home with just a warning. Brandon said, "I'm not telling you anything until I know who my sister is." Officer Colton told Brandon, "You don't have to talk to me, and you don't have to give me any information." Then Brandon saw Katie, his sister, through the window. She was walking around in the reception area, talking on her cell phone. Officer Colton again said, "You don't have to tell me anything, but you and your sister are probably going to go to jail and spend the night there if you don't tell me the whole story and resolve this situation before I have to go to my real job at the police station." She also warned that the punishment for Katie would much likely be much worse because she was an adult. Brandon, not wanting to see his sister in jail, began to answer the officer's questions, and he spoke truthfully for the next 15 minutes. Thank you. So now we're going to turn it on to our panelists, and they're going to decide through a set of questions moderated by Judge Josephson where Miranda fits in this scenario, if at all.
Well, we could start to my left with Attorney Cox. Do you want to comment on the scenario and the application of the case that we're discussing?
Sure, yes. First off, I think with the case we're discussing, and I think leaning over, it's JDB versus North Carolina, and involves minor children, and Miranda, and whether or not that they would be considered competent in giving just the simple Miranda warnings. And under the circumstances, I would say that they would not be, because they're minors. And as we heard in the statements by Judge Josephson, the idea of being questioned by a police officer, and obviously it's in certain circumstances in certain places, is considered inherently coercive. So imagine an inherently coercive environment and then put a child in there, and how much more coercive that could be, because now they are not a mature individual, they're not someone who is considered to be competent in many areas and can't make their own decisions. Why now, as a child, would we say they can make such decisions simply because it's a confrontation between the child and a police officer? And in this situation where, although the individual was originally a part-time security guard, she put on her uniform, she put on her badge, she put on her gun, and so she was a police officer. As far as that child was considered, this was a police officer with all the authorities that go with it. So as a result, a Miranda warning should have been given in such a circumstance.
Thank you. That's the defense perspective. Do we have a contravailing perspective from the prosecution and then from perhaps our police officer, if you want to? But
Well, as far as from a prosecutor's point of view, I would expect the defense to be filing a motion, what we call a motion to suppress the statements given by the juvenile. And the way I would then defend that motion would be that, first of all, the officer had an honest belief that the age of the young man was over 18, and that he was not in custody because he could see his sister. She did say, I believe she said he could leave. And he did see his sister through the glass window talking on the phone. I would have to tell you it most likely would be a losing argument on my part, because even though she wasn't on duty, this was a pretty coercive environment in this case. And when an officer tells you that you're probably going to jail, that's kind of, I would have a hard time arguing voluntariness, because I would have a hard time convincing a judge that this was just a conversation, that this was conversational in tone, and she was just trying to ask the facts, and there was no coercion whatsoever. So the fact that she was in her police uniform also does change the scenario a bit. So I would have to say at that point, I would probably have a very hard time defending this, and Miranda would be proper in this case. Maybe
Officer?
As an officer.
I'd agree. Miranda would be proper in this case, especially if you're putting that police uniform on, then you're taking the responsibilities of that uniform.
good point.
If she's gone through any form of training, she knows that, the security officer. As for the following questioning, the sister's 18, she's an interested adult. She could possibly
But
allow it
she wasn't brought in.
if she was brought in.
No, sorry.
Well, could she be the interested adult? And I'm not just asking you, but could she be the interested adult to protect the rights of her little brother when she is also a suspect and she has her own interests, and why having her brother take the fall, so to speak, would be in her best interest? Mm-hmm. Just a thought.
Any good police procedure tells you to identify the person you're dealing with. If you can't identify them, you're not going to follow up with Miranda and questioning.
Right.
You're going to get a positive ID. A 15-year-old looking 21 isn't out of the realm of possibility. I see a couple people out there that could probably go into a package store and buy beer right now. So,
don't give anybody ideas, please. Well, let me ask. I don't know if we want to open it up for discussion also from our audience and questions. But if you do have questions, please raise your hand at any time. I'll be happy for us to be able to do that. But let me at least move perhaps to a question. If our panelists can think of an example when Miranda rights had a large impact on the outcome of a case. Are there any that come to mind?
I do have one, and then we will get to the question. Yeah. I actually have one that just occurred about a month ago, and the defense attorney's in the room. And it hits on each one of the factors. We had a case out in Orange where we had a breaking and entering into an empty house, and the police tracked suspect, and they went to the house and they questioned the young man on his front stoop, and his mother was there, and he confessed. So what we needed to look at was each of the categories, and an interesting thing was the officer started the Miranda, and Mom said, "Whoa, whoa, whoa, get inside. I want to talk to the officers and find out what's going on." So the kid went inside, the mom said, "What's going on?" And then the mother went inside, this all came out later, told him, go tell them the truth. He came out, the officers did not finish Miranda, and the kid confessed and said, "Yeah, it was me." So, like any good defense attorney, you want to keep the confession out because there was a large amount of restitution involved, and they didn't have a lot of money. So I had to connect all of the dots. So I had to say there was no custody because it was on his own stoop and he was free to leave. And in fact, I said he did leave. He walked into his house and nobody chased him, nobody put him in custody, I also had to say that it was not coercive, he was conversational. And I did prove that through evidence. I had to say that just because they started the Miranda doesn't turn it into a situation that requires Miranda. And I had to back that up with my legal argument. I had to show, I had to connect each and every dot for the judge by having the officers on the stand, and even when the defense attorney put their witnesses on the stand, by cross-examining them to show that there was no custody, that there was an interest, even though there's no custody, no Miranda was required. But what I also try to do is shore up every single argument. So I said it was no custody, it was in his own front doorway, he was free to leave, and I showed that he actually did leave. But his mother was present, so he did have an interested adult there, and that it was conversational. It wasn't coercive. It wasn't like the Gestapo there telling him, you better do that, you better tell us what happened or else. It was free voluntary confession. And, she fought very hard, but I ultimately did win, and as a result, we didn't go to trial. We submitted a plea, a disposition that hopefully we all believe is fair. But that was just recent, and that just came out, the decision just came back about 2 weeks ago. So it's very important to know your rights and think about that.
I think one of the things we have to remember of why we have the Miranda is not so that people can get away with crime, or that there's, and I'm not saying in a particular situation, but the Miranda is to help people from being coerced to do something that may not be truthful or may not be in their best interest, because they've been sort of manipulated into something that they wouldn't have done if they had their ability, their voluntariness, or their will about them. And for children, it's even more vulnerable because of their age, their inexperience, the fact that they are really people who make a lot of major decisions without the assistance of their parents or an adult. And in Massachusetts, there is a part of the juvenile system that isn't part of the adult system, that not only do you have to give them the Miranda warnings, but they also have to have an interested adult present to assist that child in making those decisions. Because we've all heard about false confessions, and we've all heard about people who, because they're not educated, or they may have other vulnerabilities like mental health, substance abuse issues, that they are easily coerced into doing something that if they had the presence of mind, they would be like, I didn't do that, I didn't mean that, that's not what I meant, but that may have been what I said. And from a defense attorney's perspective, that's what we hear. A lot of time, people who have made certain statements is like, well, that's not it, that's wrong, I didn't say it that way, he wrote it wrong, or the police may have turned it in his mind in a different way. Or that, as we've heard again, false confessions. I said it because they told me they'd let me go if I said it. Or they told me they'd put my sister or me in jail. I've never been to jail. I don't know what that is. I don't want to go away. I want to go home to my parents. So there's a lot of reasons people do things or say things that they wouldn't otherwise say or do because of the circumstances they're in.
Well, I wonder how many of you subscribe to the notion that, well, people wouldn't say they did something. They wouldn't confess to a crime they didn't commit. Does anybody think that's a true statement? Oh, well, good. Because that used to be the view, is how in the world could somebody say they did something that they never did? And now we know, because of DNA evidence, there are many people who said they did very, very bad things that they really did not do. So these kinds of protections, we are becoming aware that more and more how important they really are. I think there are some questions.
You read or see in the media that the question of when to Mirandize a suspect seems to be is an issue if they're in custody, not if they're on the front porch of their house, but it seems to be an issue, and it's kind of a fuzzy line, and I wonder if you would address that. I don't know, it might be different in different jurisdictions, but how does it apply in Massachusetts?
Being a patrol officer, more often than not, when I present somebody Miranda, it's in the field. And when I decide to do it, it's obviously you have the custody, you have the control of that subject. Sometimes when you're on the fence about it, you don't typically present Miranda until you have charges, until you know this person is a person of interest. If it's a witness that turns into a person of interest, you stop and you Mirandize. Once you realize you have an arrestable offense or that they could be a potential suspect, you're going to Mirandize because you can't lose a case. Going back to cases that we could think of recently that had an impact on the outcome, I had seen a hand-to-hand drug deal walking Main Street one day. 3 guys walked up to a car that was loaded down with, I think, 3 or 4 guys. Quick hand-to-hand, they walked the other way. Being on foot and probably 2 miles away from my cruiser, I had called for another unit to stop the car that was involved. I chased the 3 guys. I was able to get a hold of all 3 of them. Guys that I had arrested probably 3 or 4 times prior. Heavy drug users. And one of them was a big drug dealer. And because it was the heat of the moment, I put them all in cuffs, except for one. I only had 2 sets of cuffs on me. So I had 3 guys. It was just me waiting for somebody else to show up. And instead of presenting their Miranda rights to them, I said, "You know your Miranda, right?" And I lost the case because of that. But, the honesty factor plays into that, too. I'm not going to fabricate that I had read my Miranda rights to them because it's not worth it, It's just a small situation. But that'll stand out.
Yeah.
And I'm happy it happened early on in my career because it'll never happen again.
Wow. And it is important that we acknowledge our mistakes, and you made absolutely the right choice in not trying to gloss it over because judges remember, and we talk to each other.
Right.
Oh, I don't know.
And well, and it's different than a custodial interrogation in the
Yes.
sense that it's not a state police detective with somebody in a closed room. It's that's the perfect situation. This I had just chased 3 guys. There was a little adrenaline and a little fear. So
How'd you catch all 3? That's really impressive. Where's YouTube when we need it? There's a question first.
What if you are listing your Miranda rights to this said criminal and then you not word it correctly or forget one of the rights, and could they hold you to that in court, and would you lose just because of a mispronunciation of a word?
Those are suggested. The Supreme Court, those are suggested Miranda rights. You have to hit each of the rights. What the police reading the card is actually the perfect, and it's smart to read exactly. It's always smart to quote the Supreme Court, but you don't have to. You have to say everything they want you to say. So as long as you get exactly what they mean, get each of those rights in, then that's okay. However, that's why we print up the cards, and I think that's why they give them out at the police academy. But the best thing, I don't know if you've ever heard this, but you will for the rest of your life, best practices is doing something a certain way every time so that you don't miss. Yes, if you do miss an entire line of the Miranda and you forget the lawyer part, or you forget the silent part, yes, you will lose. I will, because that's me. Because she will pick up on it. That's her job, to say, the police officer missed that. And then I'm the one standing there reading the police report saying, you're right. And then we have to, doesn't mean the case is gone necessarily. There might be other evidence, just like in the Miranda case that the judge read. Remember, it went back to, the Supreme Court sent it back, it went back down and they retried it. And he actually was convicted on other evidence. So it doesn't mean it's gone, but it means the statements are gone.
I was wondering when, on that case, they were talking about, well, your sister. I find it hard to believe that she would somehow be a guardian to her 15-year-old brother. You know, I'm just wondering how that would play out.
Well, I think it said before, I think she's also a suspect, first off. So she has a conflict rather, with being an interested adult for the child. Because of that, she can't really be. But 18 versus if it was even 23 or 25 or 28, when do you determine someone's an interested person? I have had cases where people try to bring in the older brother or the older sister, and that's the big argument. Is like they're not interested if they're still considered on the cusp of being a child versus an adult. There has to be an adult in the room. And a lot of times they used to try to use any adult. You know, let's just grab somebody. And it's like, that's not the rule either. It's got to be someone who's interested in this child. So you can't bring the next door neighbor over and say, hey, you know, can you sit here? Because the idea is that the child has a person to consult with. And one of the things with siblings is like, do they really think they're going to have that type of respect and interaction? Or are they going to be more like the warring children? So there's a lot of factors that go in to determine what is an interested adult.
I've had police departments call me when they've had a juvenile in custody, and the only person they can get in contact with is a sibling to come down to the police department for questioning. And I usually tell them, best practices, it's a phrase, just wait for the parents. Just wait for the parents. I know you might lose the momentum, you might lose it, but you're going to lose the statement if you don't. So that's what I recommend.
That issue of what really constitutes an interested adult who can protect essentially the rights of that juvenile. I was at a judges conference this weekend and learned that there's a case making its way through our courts in which a juvenile was going to be questioned by the police, and in fact, the way somehow he came to police attention. But the first thing that happened was that he came home. He told his mother he had committed a horrible crime, and his mother said, "Well, we need to pray about this," and they did. And at that point, the mother said, "Well, your soul is really going to be affected if you don't go to the police and confess. So when the police come, I want you to tell them, because this will protect your soul, and whatever happens here in this earthly realm, so be it." The question is, was because he did give a statement, he did talk to the police, he was convicted. Was that really an interested adult? Was that somebody who had his best interest, perhaps his soul's best interest? But anyway, that case, that was the argument on the other side. It really baffled all of us in a way. We were kind of, well, we'll be interested to see how that comes out.
I was kind of wondering if what you think the argument might be like for a case like that, because it seems like it would actually be a pretty strong argument to me that the person would have their best interest in mind if the kid came home and said, you know, I've committed this crime. It almost seems like, while there are some other factors there that would suggest otherwise, that our system would probably lean towards, well, they said they did something.
Right.
It's more towards going with due process and admitting. I don't know.
Your view is a legitimate one, obviously, but what do you think?
Actually, there is a Supreme Judicial Court case, and I don't have the name, that on an interested adult and what constitutes an interested adult. It's that came down, and it's not a new one, but that the mother was found to be an interested adult when the child it was an arson, and a firefighter died. And this was quite a while ago, and the mother was angry, and she told her child, "You have to tell the truth," because it was so serious and this firefighter died. Through all of the Supreme Judicial Court did hold that she was an interested adult just by saying you have to tell the truth. Now, this new scenario kind of really gets deeper into more of almost a coercion, kind of getting at the child's emotions. This was more, because they try to think, is merely telling your child you have to tell the truth, does that take them out of being an interested adult? And this mother was very angry, almost hostile in the questioning. But the Supreme Judicial Court came down that she was still considered an interested adult because she did consider the legal ramifications. And so it's going to be interesting. I'll turn it over maybe to a defense attorney.
But the distinction to be made is it your interests, and meaning your beliefs, your anger versus the child's, and whether or not that child should exercise their rights. So for the interested adult, they got to put them aside. Like, as defense attorney, we put ourselves aside, or prosecutor puts our judgments aside. It's not about my judgment. It's not about, our person's judgment. It's about what's good for the child to do. We forget, again, it's whether or not they should exercise their rights. And it should be an adult who's interested in the child and what they should do, protect their constitutional rights. Not that I believe that your soul will be saved if you confess. And my interest is that I want to save your soul. My interest should be what is good for you. If it was, instead of what is good for what I think is good for you.
Interested adult, what does that mean?
That's a very good question. I'm sure it's somewhere. An interested adult, what is your...
Well, as usual, as we always hear, it's all case by case as to what is considered an interested adult. And I think one of the first things is whether there is a conflict of interest. Sometimes a parent can't be the interested adult if they are the alleged victim of the crime. If it's a fight between a parent and a child, then certainly that parent can't stand in the shoes and say, "Child who I've just had a fight with, tell the police officers what you did." Because their interest now is about them as the victim versus I got to protect my child's rights. So it's got to be somebody who has no personal interest in the case, and who I think needs to know who the child is, what their aptitudes are, what their weaknesses are, and to be able to talk to that child and say, "Listen, these are your rights. Do you understand what these rights are? Do you know what this means?" And to be able to guide that child in making decisions. So in some ways, I think the interested adult should be someone more who has some awareness of what is the law and what the ramifications of them are. But in most cases, a parent is considered an interested adult because that parent obviously would know the aptitudes and the weaknesses of the child and would be concerned about protecting their child. Aside from that one circumstance where they may be the alleged victim. So in most ideal cases, I think the parent is the person that people are going to be looked to as the interested adult.
Say someone gets arrested and then you go to fill out a statement at court and so does the victim. What happens when it comes to court and then there's a trial, but the person is switching up the story that they wrote on the statement?
Ms. Cox will make mincemeat of the witness because there is a rule of law called a prior inconsistent statement that allows that person's credibility to be judged based on the fact that they have made a significantly different statement at an earlier time from the testimony they're giving under oath. Now, of course, Ms. Rock is going to say, well, really, it's not that inconsistent, and there's a very good reason why that person said something different if we're talking about a victim statement.
Are there any parts of that witness statement that would definitely be true or could be considered true even if parts of the story changed?
But that's the jury's job because none of us were there. And that is the whole reason we have trials, because we have two sides of the story, and it's very difficult to figure out exactly what happened at that time. And the police have to deal with that on an hourly basis.
Well, I wonder if there were a statement, let's say it's a confession, so to speak. Does that change it? Does it change it? That, here's somebody who said, I was at Wendy's at 11 o'clock, and that's where the event occurred. And then at trial says, well, I said that, but that really wasn't true. I was being coerced, or I wasn't advised. There's any number of ways that a statement can be challenged, whether it's by a defendant or by a witness, really, the accuracy.
If they change some parts but they don't change other parts, do those other parts stay consistent?
Well, we're talking now about hearsay, and any statement that's given outside of court that is being offered in court can only be given under certain exceptions because only testimony is admissible in court. So I don't know if that helps in the answer.
Assuming there's some portions that are still consistent and other portions are inconsistent and both statements come in, one being in court and one being the prior statement, there's a jury instruction that basically says you can believe portions of their statement, you can believe believe all of it or disregard all of it. So there's instructions to say, yes, you may not believe 100% of what someone says, but you may believe certain parts of it. And that's a jury's decision as to what parts of a person's testimony they decide to believe.
So what if I was arrested and I make a statement, but then I'm smart enough to hire a good defense attorney who then files the motion to suppress, and the statement is thrown out. But I'm also somewhat bullheaded, and I still want to get up on the stand and tell the jury that where I was and what I did and that I really am innocent. What would happen under those circumstances, and what could my statement be used in any way in that scenario?
Would anybody like to talk about the exclusionary rule and that?
I'll let you start.
Well, I would argue that it was a prior statement, and this would be, it's a prior statement made by the accused, and he's making an inconsistent statement. Then it would be vehemently argued by the defense.
Well, again, it goes back to the right to remain silent and the fact that whether or not they're informed of those rights. Because again, in the coercive environment that a interrogation takes place, there are certain things that could happen that's not the truth. Just sort of pulling back in our scenario is that, you have the young man who comes in and says, I told them everything they wanted me to say because I knew that would get me out the door. So I said I took the paisley tie and I put it in my back pocket and I walked out and I'm totally responsible. It's only me. And doesn't tell the actual story that happened. So why should that other story come in simply because it was done in a manipulative fashion because he wanted to get out of trouble. He didn't want to go to jail. So I would ask that since the Miranda warnings were not given, it should be excluded. And that his testimony at trial should be the only testimony that should be allowed because that, again, is more likely to be truthful because it's a present sense. He's under only the pressures of the the witness stand, but not the pressures of an officer in a custodial interrogation.
And he's had plenty of time to practice and be prepped by his attorney and to think of his story, and maybe his defense attorney should have sat on him and told him not to talk.
I want to know that.
Can I tell you how I think the judge would rule? I think it would be admissible. And I think it would be admissible because there are cases that suggest that although it cannot be used in the case in chief against the person, it can be used to impeach that person's testimony at trial. However, I would be duty bound if I were the judge and I allowed it in to give what is called the humane practices instruction to a jury, which we have in Massachusetts, and that says that before any jury may consider any statement by a defendant, the jury has to be satisfied that that statement was voluntarily given and was the product of a rational intellect. And that is separate and apart from anything that we do under the cases that we're discussing here. And it is called the Humane Practices Rule in Massachusetts, and it's good we have it. Oh, impeach? What do we mean by impeach? I'm sorry, we get into this jargon. Do you know, some of you may know, some of you may not. Impeach means to detract from that person's credibility and make them appear to be unreliable in the statement that they've given.
Right after it was decided to use the Miranda rights, could past cases be brought up again?
It did not. No. It did not. Imagine. I mean, it may not seem, does that seem fair to people? That you can't go back, 10 years and say, hey, wait a minute, I didn't get my Miranda rights and I got convicted. Mm-hmm. How, there are, I think you can say, how is it fair that, it happened today and yesterday I got convicted? But honestly, there has to be some point at which there is finality. And actually, there are cases that say that very thing.
Mm-hmm. Mm-hmm. When you were discussing the fictional scenario, that it seemed to make a difference if the woman was acting as a police officer or as a mall employee when she was questioning the suspect. Mm-hmm. Is a mall employee required to give Miranda rights?
Let me ask you a question. Is a mall employee able to restrict somebody's movement in the same way as a police officer could?
Sometimes.
Or make a suggestion of it, or call the police if the person gets up. But, that just was, let me turn it over to the panelists because I think there's an answer.
I think you can even extend that to teachers or in particular principals who bring kids into their offices and ask them questions about something that may have happened at school or something that sometimes is ancillary to the school, as to whether or not they would be sort of like a show of authority, or they would be taking on the place in place of the police officer. And I think in the situation of a security guard, I think you can say yes, they're still, although they may not have a gun, hopefully not, they still have a uniform, they still have a badge, and they still have an authority position. They can take people, put them into a security office, and keep them there and restrain them. So wouldn't that be still a show of authority? I'm going to call the police if you don't talk to me now. And the same idea that I would use is for the principal or a teacher. They have a authority as well. And so they take on the role as a police officer. And as a result, they should be held to that standard of using something of Miranda. But I'm going to defer because I know that my feelings on that part don't really convey to the law with respect to teachers and as you go down the line.
Right, and that's where just because they have the appearance, they do not have arrest powers. And they are not acting, I would argue, they are not acting as an agent of the police. The only time Miranda is required is if the person doing the questioning is acting as a direct agent of the police. If Officer Gilbo says, okay, mall security guy, ask him X, Y, and Z, I'm on my way, then that person needs to be Mirandized. But other than that, mall security guy is actually a private citizen. So that person could get up and walk out. And if they restrain them, mall security could be sued. Well, all right, I'm not a civil attorney. So that's, but that's a whole, so the only time Miranda is required is when a police officer or a law enforcement are acting, or when someone is acting as an agent of a law enforcement. And there has to be a direct connection. So, no.
I'd like to suggest that as the prosecuting attorney, you could have made a stronger argument at the very beginning of the session, rather than saying that it was a weak argument, because the woman who was doing the questioning, she was wearing a, but she was not acting as a police officer. I could put on a police officer's outfit and not be acting as a police officer and done that questioning.
But no, she actually was a police officer,
Right, yeah.
and just because you haven't started your shift does not mean you can't arrest somebody. And she was in her own jurisdiction.
She was acting under color of
So
authority.
she's acting under color of authority. When you're wearing your badge, your uniform, and your gun, you close a door and you say, you and your sister could go to jail for the night if you don't say what's happening. Look, I've been a prosecutor since 2004. I evaluate, he's 15. Now, could I fight this all the way? It would depend on what was stolen. It would depend on the victim. It would really make a big... You have to evaluate the case.
It would depend on what was stolen?
Well, it would really depend on the crime, on why I would be fighting the Miranda. Okay, on a shoplifting, would I be fighting the Miranda so hard? No. On another case, would I try to fight the Miranda a little bit harder? Possibly. I think it would depend.
I think you also have to look at the fact is that it is a police officer and he has his uniform on. It's not as though he was still in his security guard mode and he had a security guard outfit on. And that may be a difference too. But here he's under the color of the police. Police officers can make arrests while they're going to work, going away from work. Sometimes when they're not even wearing their uniforms, but if they're in their uniforms, then it's a show of authority. And that's what we expect, that they have all the powers that go along with that uniform. So in that circumstance, why bang your head against the wall?
This was a losing fight.
And
I could bring everybody into court, but this was a losing fight. Right.
So you're saying that there is also an evaluation, if I'm understanding
Yes.
it, as to the proper allocation of resources.
Correct.
And what is the best use of the scarce resources that the Commonwealth
Correct.
may
That's-
have to be able to prosecute cases. And thank goodness we have District Attorney Sullivan and his staff who are very good at making the right calls on that.
But you just said that when you evaluate whether or not to fight the motion to suppress, part of your analysis has to do with the nature of the crime. But how much of your analysis has to do with your own legal conclusion as to whether or not it was a good confession or not? Now, I've always been of the understanding, and having practiced law both as a defense attorney and as a prosecutor, the standards for us are different. When Ms. Cox represents someone, she has a duty to do everything ethically possible to get her client off. I had always been told as a prosecutor, my job was to do justice, which is really different. I once tried to get a piece of evidence before a jury that I knew was inadmissible when I was a prosecutor, and I got called to the bench and was dressed down for it because I should have known better. So I'm just wondering, in listening to you, when I know this is a mock trial and mock situation, but you essentially said you didn't think it was a good argument. So when would you, in terms of your own ethics, decide, yes, it's not a good argument, and I'm not going to make it? I'm going to sit down with my cop, and I'm going to, or the security officer, and say, well, these are the mistakes that were made, and you cannot do it. So when do you decide that that's more important than making an argument that you really believe is not a good argument?
Justice is a tough word. And I've been doing this for almost 13 years. And it's something we strive for every single day in the DA's office. And that's why we work towards community policing and community prosecution and education and outreach, because when you get to the court system, justice is tough to get for victims of crimes and for outcomes for defendants. It's tough. And that's why in juvenile court we work together, defense and prosecution. So when I evaluate cases as a prosecutor, I'm looking at both sides. And so justice for a stolen tie. I look at the offender. Am I going to bring in all the resources? Well, I have an ethical obligation as an attorney to follow rules as an attorney. So I have those ethics that I need to maintain. So it is a balance that prosecutors have to walk every single day when we evaluate our evidence, trying to put in something that may be inadmissible is not unethical, because we don't know how the judge is. I've been pretty persuasive. I persuaded a judge that I really thought it was a prior bad act. It was somebody who had a domestic situation, and I went through it all. I did a motion before the trial, and I got it in, and I got a conviction, and it went to the appellate court, and it got overturned. But I persuaded that judge. Now, it probably wasn't admissible, but I thought I was doing the right thing, and it got overturned in a higher court. But I thought that the domestic violence situation was worth it at the time to use those resources and all of that energy. So I have to weigh what is going on with inside the family, what's going on with the crime, and how much energy I'm going to put. Whatever it's a motion to suppress, a motion before a trial to get evidence in. That's what I do every day. And I look at my coworkers, I go to my superiors, and I ask, and we kind of work together to try to help that ethical balance.
One of the things I want to add to that is that, like when you asked the question, you said about the defense attorney trying to get them off, and that always makes me cringe, because we're for justice is just as much as the prosecutor, as shocking as that may seem. But in the case that you were talking about with respect to the domestic violence, one of the arguments probably why it's excluded, it's considered unreliable and unadmissible, is because it taints the jury and it taints their decision making, because it's not about the crime that he's alleged to have occurred, but it's about his past and whether or not, I'm assuming it's a him. He beat someone once, he beat him again. So that's why our rules are there. But as you go to the right to remain silent, and I think one of the questions was asked, is that, it's all about, you're letting someone get off. And that's not what it is. It's a constitutional right, an insaliable right to remain silent, just like we have the right to free speech. And we have the right, as under the Second Amendment, to bear arms. We're considered patriots if we exercise the First and Second Amendment. We're criminals if we assert our Fifth Amendment or ask for our Sixth Amendment. Why aren't we patriots when we assert those rights that have been given to us? And that is why, part of my job is to ensure that those rights that we're being given have meaning and they're strong. And we don't say one day, no one uses it, let's just get rid of it. So that is part of our job, is to ensure that our Constitution is held to the highest standards.
If a principal is asking questions of a student on behalf of a school resource officer, does that require Miranda?
Again, is that principal acting as an agent of that officer? Is he or she doing something because the officer has put the principal in the place of the officer?
So say there was a crime at the school,
yeah,
and the resource officer tells the principal to ask the kid this question.
Oh, absolutely. Yeah. If they're investigating a crime and the resource officer asks the principal to ask the questions, absolutely.
I was kind of wondering, how different do you think things would be in the culture of enforcing the law, specifically with to what level people were interrogated, had there not been a Miranda decision?
Living in the freest country in the world, something would have come about. As a police officer, your job isn't to get a confession. Your job is to find the truth. So I think that it's more important for me to find the truth than to get a confession, regardless of my, personal preference on the person. But, I really don't know how to answer that question.
The time that Miranda was decided, the FBI and other federal agencies and some state agencies as well were already giving what turned out to be Miranda rights. That was the standard for the FBI. That was the standard for the federal government. So even though it was a sea change for many smaller law enforcement agencies, it wasn't a sea change more broadly.
Said it earlier that the officer, the mall employee, wouldn't have to recite the Miranda rights. Would they still have to respect if someone chooses to exercise those rights?
My view is a security guard can't really compel any more than any other person. What would you say?
I would say that they have no authority to act. If you say, I don't want to talk to you, and you walk out of the store, maybe they follow you, get your license plate on your car, and call us until we get there and we can detain you and give you your Miranda rights and question you. But, if there's a shoplifter at Big Y, for instance, security walks up and says, would you mind coming back to my office with me? And if the person walks back with them, that's on their own free will. They can't force them. They can't handcuff them. They don't carry handcuffs. So essentially what they do is they call us, get that person in the room, not secured, but, there, and they'll let them know that they're calling us. But many times, more often than not, people will just take off because there's nothing security can do.
I would just like to make one comment. The lawyer in me is so grateful to the District Attorney's Office and to our Bar Association for teaching us more about the law involving Miranda. But that's the attorney in me. The educator in me just wants us to remember what Judge Josephson was describing that motivated Justice Warren to make Miranda the law. And it's this: when somebody is intimidated and frightened, what they say might not be reliable. What they say might not be the truth. That's not just a matter of law. That's a matter of how we interact with each other. And I think that that's a really important thing for us to, because if we understand that, think questions, Attorney Berlin's question about ethics or mall security, it all becomes a little more rational and a little clearer. So that's what I think we should carry away today.
Big thanks to our panelists.
The opportunity to follow Judge Josephson, who is a marvelous justice, so fair and partial and kind, and also tough when she needed to be. Jennifer Fox, who comes into court every day and really fights for her clients and fights for their constitutional rights, and Assistant District Attorney Caitlin Rock, who works in the trenches in juvenile law and isn't just about the Constitution, about doing the right thing for our young folks that are accused of crimes and sometimes convicted of crimes. I want to echo what Buzz Eisenberg just said. This is about getting it right. Really, I have two duties as a district attorney. It's to do justice and to find the truth. And I think, Ed, you had some really good questions. And I think the real thing is that when we have bad evidence, we can't use it. When we have confessions that haven't met those constitutional standards, we have to dump them, because that's our job. Our job isn't to get convictions. A lot of people think that a prosecutor's job is to get a conviction. No, it's to do justice, and there's a lot of different layers to that. And I think, echoing what ADA Rock said, is there's a lot of gray areas sometimes about a disposition. What we should do with a juvenile offender depends on their background experience, the type of crime. But I want to say that only in America, really, can we gather together like this today. Can we have defense attorneys and retired judges and prosecutors and you, the people, all gathered here and wanting the same thing, and that is a robust democracy that respects the rule of law. And the rule of law is really about you folks knowing your rights, knowing how important the First Amendment is, Second Amendment, all those amendments, to include the Fifth Amendment. And one of the cases that really brings those Miranda rights together was Gideon versus Wainwright. You know, that part of the Miranda rights that talks about the right to counsel, and not just the right to counsel, that if you can't afford an attorney, one will be provided for you. And that's what distinguishes our criminal justice system from everyone in the world, that right to counsel, that right to have an advocate to speak on your behalf. And the worst thing that can happen in a prosecution are two things: a false confession or a false identification, an erroneous identification. Those are the two reasons why we have wrongful convictions. It's when an identification wasn't made correctly, or because somebody felt intimidated or fearful, or just wanted to say what they thought somebody wanted to hear. And really, I want to compliment Officer Gilbo. He said it best. Our job isn't to get a confession, it's to find the truth. And so many good people in this system, and we are raising young people like you that have high ethics, that want to seek the truth, that are going to make these institutions, our legal institutions, our educational institutions, question those folks, and to do that. And I just want to say I really appreciate you students being here today and asking tough questions and being here and being witness and knowing this is your democracy. How many seniors we got in the room? Okay? You're going to get a notice in about another month, maybe 3 months. Guess what the notice is going to be? Jury duty. Yes. And you know what? That is so important, because that is also a constitutional right, the right to a jury trial. And it means that we need you to show up, we need you to sit on that panel, we need to have your perspective, and we need to have your voice in that jury room, because it's your democracy. And no matter what you do, whether you're a police officer, whether you're an attorney, whether you're working as a nurse, you're working at the local store, the most important thing in life is your integrity. So keep that, always cherish that, and do the right thing.